different strategies to resolve California family law cases. A conversation with Ernest Baello. That is our conversation for today. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is Mac Piolovi. Welcome back to Lawyers, Mediators International, LMIPodcast.com, where we talk about the law and conflict resolution topics to educate professionals and everyday people. So today we have special guest, Ernest Baello. Ernest, how are you doing today?
Good. Nice to be here, Mac.
Yes, thank you so much for coming. And so you and I are both family law attorneys. I'm based in Texas and Florida. You're based in California. And so I wanted to have you come on today to talk a little bit about different strategies to resolve California family law cases. And just before we get started about the topic, we remind people that everything we talk about today is not legal advice. So since things are fact dependent, we want people to make sure they talk to a lawyer and bring their issues to counsel who can give them advice. But this information is for education purposes only. So we want to just make sure we put some good knowledge out there. And you're very knowledgeable. You're a board certified attorney out in California. But tell us a little bit about yourself before we get started into the topic.
Sure thing. So I've been a family law attorney for 15 years. I got into the field in law school and very quickly grew to love it because I got to see how important it was and how much of an impact it had on people's lives. So I continued on through law school and after law school, and I've been practicing now for over 15 years, both in New York and in California for the second half of my career.
I see. So are you licensed in New York as well?
I am.
Oh, cool. Didn't know that. Awesome. So dual license. Cool. And so tell us about your law firm that you work at. It's Moradi Neuffer. And it's a firm out in California. I got the website up on my screen. So if you're listening to this podcast, be sure to check out the YouTube video where it's being screen shared, but you can go to it at californiafamilylawgroup.com. Again, that's californiafamilylawgroup.com. So tell us about your firm.
Yeah, our firm was founded in 2009, and since then it's grown to, we have 12 attorneys now. We are a family law firm that handles cases in the Bay Area as well as in Los Angeles and Orange County in Southern California. And what makes us unique is that we have lawyers that handle both litigation cases as well as a strong collaborative and cooperative divorce group. So we're able to really help people and help families, with all sorts of different dynamics, and help them through their divorces and their other family law related matters.
Cool. And do you guys do other areas that are connected to family law?
We do. So we also handle adoption cases, name changes. We do, but a lot of our cases do involve divorce as well as custody support, domestic violence, premarital and postmarital agreements as well.
Got it. So you and I, we're basically cut from the same cloth. We do a lot of the same kind of work. I'm doing more mediations these days, but family law is, where I cut my teeth. That's where I, learned all the skills I have. So welcome, brother. We do the same kind of work. But in the work we do, we are often dealing with, adversaries, but also people who want to come to the table to negotiate and work out a deal. So there's a phrase that you've told me, which is settlement first, litigation ready. Where did that phrase come from, and what does it mean for your office? Settlement first, litigation ready.
Well, it's the approach really that we try to take with the family law cases that we handle. So it really comes from the understanding that there are basically two ways to resolve a divorce or a family law case, and that's either by agreement, where the parties are able to reach an agreement with each other, or otherwise the court has to make a decision to resolve any disputes or disagreements that may exist in the matter. And that's where the litigation comes in, because the only way for a court to be able to make a decision when people can't come to an agreement is where evidence has to be presented by both sides, and both sides have to try to persuade the court to see things their way and to give them the relief that they're looking for and make orders that they're looking for.
Yeah. And what kind of ways do you guys reach agreements typically in your jurisdiction?
So, in cases where people are, say, not very far apart, or they're seemingly able to work well together to try to reach compromises and resolve issues together, then we can help them through either the collaborative process, which is a way of resolving divorces and family law disputes, and then also through mediation, much like what you do with regards to, sometimes people need the input of a neutral third party and can really be assisted with that in helping resolve their disputes. And with that assistance, they're able to then reach agreements without having to go to court.
Yes. And do you find that people want to not go to court? Because I'm trying to educate people on the power of mediation and the power of conflict resolution. Or do you find that people just want to go fight? Like, what's been your experience?
More often than not, virtually all people will say they don't want to fight.
Yeah.
They want to reach an agreement. They want to stay out of court, and that's understandable. Court is expensive. It's there's a financial and emotional toll to going through that. But the thing sometimes that gets overlooked is that, well, one, you can't force someone to agree
Correct.
to what you want in particular. Not even the court can force someone to agree. The court can make decisions about people's lives and make orders, and whether or not someone agrees with it. But no one can really force another person to agree. And so it's a situation where certain cases are better suited and ready for mediation and or for the collaborative process. And the good news is that a lot of cases, really, even ones where there are disputes, can go into that, can benefit from those paradigms and those approaches. And then for cases where or issues where there's people either they just have a good faith disagreement, and there are arguably different ways of looking at an issue, then then sometimes you do need to bring that to court, and you just need someone to make a decision on that. Or in cases where, if unfortunately the dynamics between people just aren't ideal, then sometimes you have to go to court there as well. So.
Yeah.
Now, that said, I mean, I've had cases where the things can go back and forth. Like I can think to a case that I handled not too long ago, where it started off with probably the worst dynamics you can have, with domestic violence and competing requests and just a lot of acrimony and conflict. But the good news is that kind of once the dust settled, and we were able to get a status quo established, then that allowed people to also have the separation that they needed from each other to really take a step back and to approach things a little more collaboratively, and to be able to work through the remaining issues in their case once the more difficult ones were resolved.
Yeah, no, I totally agree with you about that. You see sometimes a case start really hostile, and then you're shocked they end up getting wrapped up amicably. Sometimes because family intervenes, sometimes because the person just had to sleep on it and think things
Mm-hmm.
out. Sometimes because someone says, "I'm sorry." I
Mm-hmm.
sometimes I think that's the most powerful word when it comes to conflict, right?
Mm-hmm.
But the opposite is also true. Sometimes you have people who come to you, they want a agreed divorce or agreed custody case. They say, "Oh,
Mm-hmm.
we've already talked, we've already worked out some kind of plan," and
Yeah.
then you start asking questions. You start kind of probing a little bit about, did you think about this? What about that? And then before you know it, they're at each other's throats. And so I've seen that a lot.
It does happen, especially in cases where if there are dynamics, for example, I see where if one party is potentially more dominant than the
Hmm.
other, and the less dominant party first is pretty much just agreeing with the other part
Yeah,
with their partner or their spouse, but then once they get the benefit of legal advice and they're able
exactly.
to understand better what they're entitled to potentially under the law and things like that, that can get them to see things differently, or once they get to see big picture what their lives are potentially
Hmm.
looking like, as far as the different potentials for themselves and for their children. And so, generally, what we really try to do at our firm is make sure that our clients are making informed decisions. At the end of the day, everyone is at the end of the day makes their own decisions about their own life,
Yeah.
but we feel it's very important that those decisions are made with the benefit of information and of proper advice.
Yes. So let's talk about court. All right. So let's say a person winds up going to court, maybe because they want to, because that's where they believe they're going to get justice, or they're kind of forced to because even though they want to make a deal, the other side is being unreasonable from their perspective, and they're forced to have to go try the case. So a lot of times, people don't know what court looks like. They see it on TV. You and I are in it all the time, and so we're kind of used to the dynamics that are happening. And people sometimes think they can just go to court and just say anything they want, right? That they just get to get on the stand and tell the judge whatever they want. And I'm just like, client, that's not how it works. There are rules. There's rules of evidence. It's yes and no, and you're going to be objected to if you go too far. Can you talk to us a little bit, for the people out there who have not gone to court or who, want to just know about the experience of a trial? What can you tell us?
Well, it is definitely not obvious or user friendly, and so definitely having the guidance of an experienced family law attorney to be there with a person is something that I generally always recommend, because
Yeah.
even very intelligent people who think they can explain things well, family court requires that things are explained a certain way and that arguments and positions are presented a certain way for
Yeah.
them to be the most effective and the most persuasive.
Totally.
And it's something that you really only learn over time, over years of doing this,
Yeah.
of going through trials, of going to hearings, and getting to know the judges, and getting the benefit of seeing different patterns and learning how to simplify things, and present them in the most succinct and digestible way possible, and knowing when to zoom in and zoom out on certain issues and certain facts to be able to present things most effectively. So it's one of those things where there's a lot of preparation, a lot of strategy, and a lot of thought that really goes into handling your regular support hearing,
Yep.
or attorney fee hearing, all the way to a multi-day trial. So like I mean, the we do a fair number of trials at our firm. I've had the benefit of doing a number as well, and every time you have to really make sure that you're marshaling your evidence properly, you're preparing your witnesses
Yeah,
so that they're able to really testify and explain things in a way that is really going to be effective for the judge to hear what you're trying to present, and that you're able to get as much of your evidence in that you're trying to get in, as far as getting exhibits in and making sure you've handled all the technical details that go into that.
exactly. You can't do that with AI, right? Because we have a whole new wave of ChatGPT, folks, and it's all about, hey, this AI can help me prepare for court, but no, you need an attorney on your side because this is a human thing, and there's these judges are human. Some of them are fickle, and they will take it out on you. And so, going in with somebody who knows, how this works on the ground is kind of critical. Let me ask you this. Who are the fact finders in California family courts? In Texas, we're able to have jury trials for divorces and custody battles. Is that the same in your state?
So we do not have jury trials in California. With family law, we do have we that the fact finder is a judge.
Yeah.
There are, so generally speaking, family law cases are going to be heard in the public court system
Yeah.
in each county. There's a superior court and there's a family law division that handles family law cases. People do have sometimes the option of using what's called a private judge,
Yeah. Tell me about that.
where there are attorneys who offer what are called private judge services, where they're able to essentially act as a judge in various capacities, which can help expedite things, but also and also provide more individualized attention to certain matters, which can be good for more complicated matters, that where you're looking to perhaps get a trial sooner, or have the benefit of a very experienced family law attorney determine a very complex issue.
Yeah. Yeah, because my question would be, why would someone, choose that? But you said one of the reasons is efficiency and speed, right? You can get your matter heard relatively quick instead of having it go through the typical public process.
Some so well, understandably, the with a lot of counties, you can be waiting a while for trials, for example.
Yeah.
Like in some counties, it can take over half a year before you can even get to trial from the time that you request it. So a private judge can allow, for people who can afford to hire a private judge, and where it makes sense to use one, that's a potential option to have it heard on a more expedited basis. Then there are also some private judges that will offer services as far as reviewing paperwork, where people do have an agreement, and even the process, even when people have an agreement and you're just submitting the papers to the court, it can take a while. It can take several months before the paperwork can get processed. So
Yeah.
private judging can be a way to potentially expedite that.
Okay. And is that something you could do, for example? Like you could just say you want to become a private judge and you hold yourself out publicly and people come to you for that purpose?
Some people do. Some attorneys do that. Yeah,
Interesting.
they kind of segue into that.
Yeah, it's very different from what we have here. I mean, we have arbitrators, of course, who
Mm.
can, people can agree to have that person act as that, functional role of a private judge. But tell me, what does it mean to be litigation ready for your firm?
So when we talk about being litigation ready, we're looking at it. We're looking at it from a bunch of different ways. So one is, for every case, we want to understand what are the likely outcomes if the court is going to, if say there is no agreement between the parties, what is the court likely to do? And you can never be sure, because there's always a level of uncertainty, but you want to try to understand what the bandwidth of possibilities are as much as you can, because that allows us to advise our clients as far as, okay, if we have to litigate this case, then what are the potential outcomes that you're looking at in your case. And that then allows us to negotiate more effectively in terms of trying to accomplish our clients' goals, and making sure that our clients' goals are also within what's possible in a family law case. The other part of it is a lot of times just being ready to litigate a case, and if God forbid, we're not able to reach a resolution,
Yeah.
then that being able to do that and being able to show that to the lawyer on the other side, for example, that provides a lot of allows us and our clients to enter situations with a lot of confidence,
Yep.
and to be able to negotiate effectively towards outcomes. And
Yeah.
if needed, if a resolution really can't be reached between parties, then we're ready to go to court and to put on the best case possible.
Yeah.
If say, I mean, we've had I've had a case that comes to mind is we were representing a client who had a number of business interests, like 20 businesses, very complex set of assets and a network of businesses, and a lot of complicated issues that we had to really unravel through that and advise our client as to what we thought the court would likely do in dividing these businesses and allocating them. And we went into mediation with regards, on behalf of our client, and we were able to thankfully negotiate a very successful outcome for him.
Yeah.
But that only happened because
You're
we
ready.
had everything lined up, that if
Yeah.
we weren't able to reach an agreement in mediation, we made it very clear we were ready to present our case in court, go to trial, and present a very compelling case at trial with our experts and everything that we had worked up in that particular case.
Well, that's a good strategy. You're ready to go, but settlement first. So,
Yep.
cool.
I mean, the way the way I like to look at it is that, I mean, it kind of goes back to like, well, when I was a kid, as I think with a lot of us, we've all known bullies
Yeah.
in school, right? And I found as a kid that the best way to stand up to a bully is to really show that you're not afraid, and that
Yeah.
you're going to stand up for yourself. And so we take that same approach at our firm, where we're not looking for fights, but if someone is going to pick one, then we're going to fight it, and we usually win.
Yeah.
So
That's a good analogy. Yeah. Okay. So tell me about when people act in bad faith. Speaking about bullies, sometimes divorce can sometimes bring out the worst in people. I think that's something that a lot of people know is to be true. People can become underhanded sometimes. You're dealing with things involving children, not just high net worth divorces where you're just talking about money and assets, but when we're talking about human beings, right? And people can do things that could shock your conscience. They may lie. They may accuse another parent of doing something inappropriate that didn't happen. Just to get the upper hand, they might call child protective services, for example, to fabricate certain evidence in order to try to get an upper hand. So when you have these kind of situations happen, how do you deal with it? How do you deal with someone who is acting in bad faith and who is not being totally honest when it comes to the litigation aspects of the case?
So in those situations, we take special care to advise our clients that we need to take the situation as it is. We have to, and it's especially important to be prepared for things that that might occur, that are going to be done in bad faith. And the best way to combat those things is to be ready, to be proactive, particularly in custody. cases, really anticipating what the other side may do, and really telling our clients to really be careful with in terms of documenting things, and in terms of what they're being careful of what they're putting in writing, for example.
Yeah.
Not letting the other side bait them into potentially getting into an argument or saying
Yeah.
something that that could be twisted against them. And that a lot of times less is more when it comes to these communications that can occur between parties while divorces is going on, to be careful, and really being there for our clients to guide them through these, especially in the beginning, when people are still are new to these situations, and to co-parenting separately, or to
Yeah.
now interacting with your spouse or partner while the divorce or family law action is pending. So understandably, a lot of people don't have an instinct for how to deal with those things. And so a big part of what we do is really guiding them through that and helping them develop that instinct, so that they eventually start to see the patterns a little better, and understand what to do in those situations, so that they can avoid people acting in bad faith. And then as far as as far as the court case, really understanding from the start that, look, maybe this will maybe things will turn, and it's still certainly possible to reach a settlement and an agreement, but
Yeah.
it's really best for us to approach this from the starting point of, if we had to persuade a judge to make orders in line with what our client wants, then what would be the best way to do that? What strategies would we be employing? What information do we need? What documents do we need to gather? And that we really just jump in and get started with that, to build up that case as early as possible, so that we can have that as our foundation and negotiate from there.
Yeah. Well, so it sounds like to me that you do all this work on the side so that you're negotiating from a position of strength, right? A position of confidence, so that you can try to get what it is that you want at a negotiation table. And if you can't, well, then you go to court. And but in mediation we have these acronyms. One of them is called BATNA, the idea that when you corner your opponent, they're going to be thinking, is the offer that's being made to me right now better or worse than what the judge might give me? And so I think you're always going to be, keeping your opponent on their toes, with that question. And they have to wonder, should I just settle and give them what they're asking for, or just take my chances in court? But if you're prepared, then you're going to have, you'll be in a stronger position. So understand. Ernest Baello, thank you so much for coming on the LMI podcast. And I will remind people of your website, and that is CaliforniaFamilyLawGroup.com. And folks can check you out and learn more about you there. And you're in LA, Bay Area, and now that I know, New York as well. But I don't know, do you practice in New York all the time, or is that, because it's kind of hard to do two different states simultaneously, I would imagine.
No, I've focused my practice on California
Yeah.
at this point. So New York's where I started, but my
Gotcha.
my practice is now in California. So
Understood.
Bay Area and in Los Angeles.
Cool. Well, thank you so much for coming on and educating, the audience, and anybody who has questions about family law in your jurisdiction in California, now have a place to go and check out. All right. Thank you so much.
Thank you, Mac.
All right, everyone. Until next time, check out this video and all the others on LMIPodcast.com. Also on the YouTube channel, LMI Podcast. Take care, everybody. Bye-bye.